Appeal dismissed.
I may be allowed to move an urgent interlocutory application in a pending criminal appeal. Urgency is that the appellant's mother passed away last evening, and that is why we have filed the interlocutory application seeking interim bail. Appeal has already been admitted on 4th of August.
What is the offense?
302 life imprisonment.
Life imprisonment.
Lordship. He has already moved an application under 389(2) for suspension of sentence. In that application, notice has been issued that is pending. LCR has been called for.
When?
But-
Tomorrow?
Lordship today itself, because eldest son, he has to perform the rituals.
When? Today?
Lordship today.
Is it today? Will it be done today or tomorrow?
Today, Lord.
Generally, it depends upon the timing
time.
of dates. If the
Last evening.
night time, then next day.
Okay, let him, okay, 2 o'clock. 2 o'clock.
Lord, alright, alright.
Or anytime where it comes.
Yes.
May I please, your lordship, I beg to mention item number 17, lordship. We take
17 years.
lordship. We've taken consent from the other side, lordship. This
Okay, on
is
the prayer for adjournment made on behalf of Mr. H.R.A. Chowdhury, which is not objected to by Ms. B. Buyan, addition PP, this is the matter after a week.
lordship. Obliged, lordship.
Yes,
Maybe the lordship.
Beg to mention for listing IA criminal of 2022 in criminal appeal. Actually, we are convicted for 12 years.
when do you want?
Tomorrow, your lordship. Much obliged.
May I please, your lordship? I beg to run 15 and 16 minutes.
Yes,
Taking the consent of the other side money. In parts of the day money.
okay, right. On the prayer for adjournment made on behalf of Mr.
BK Margin.
B.K. Mahajan, the counsel for the appellants, which is not objected to by Ms. B. Buyan, addition PP. This is the matter after
1 week.
a week.
Obliged.
That reason, Lordship has asked to obtain an information whether any undertaking is taken at the time of when there is no such undertaking taken, but Lordship will find. And
Let us see the judgment of the apex court,
Lordship,
the latest judgment.
Lordship, Thomas Daniel or
Thomas Daniel.
Lordship, only aspect is this, all these cases, the petition or the appeal was allowed on the ground of hardships and equity. But the aspect of that CCS pension rule 71 was never deal with any of the cases, Lordship. Lordship, can we go through rule 71 of the CCS pension?
No, just show us the judgment first.
Lordship.
Where is the judgment?
Page 63, Lordship.
Yes, no. Thomas Daniel.
Thomas Daniel, Lordship. Lordship, it's AI 2022?
That much we know. I was not able to get it. That's the problem. Yeah, 2022 SC
22
2153.
2153.
Where I need a copy of that. Can you give us AIR 2022 SC 2153?
Lordship, in this Thomas Daniel case, Lordship, the recovery was sought to be required after 10 years from retirement. That it can be differentiated. And moreover, Lordship, in all these cases, right from Rafiq Masih,
Let us give us the 71
Rule 71 was never dealt with. Lordship.
CCS rules,
CCS pension,
CCS pension rule, 1972.
1972, Lordship. Only that aspect has to be examined,
You don't
Lordship.
have. Didn't you give a copy of the, what was required earlier? You should have given them. Then they could have been prepared.
Lordship. May I just
Yes,
say,
please read.
recovery and adjustment of government dues. It shall be the duty of head of office to ascertain and assess government dues payable by a government servant due for retirement. The government dues is ascertained and assessed by the head of the office, which remains outstanding till the date of retirement of the government servant shall be adjusted against the amount of death cum retirement gratuity becoming payable. Then sub-rule 3 defines lordship government dues. I am concerned with sub-rule B. Dues other than those pertaining to government accommodation, namely balance of house, building or conveyance or any other advance, overpayment of pay and allowances. That is overpayment. Our case is overpayment of pay, Lordship.
Your case is basically on with regard to the third MACP.
Wrongly given from
Wrongly
2013
given in
ought to have been-
2013.
ought to have been 2008.
2018. So when did he join the
88, Lordship.
88 he joined?
So,
So 88 means 98, 2008.
18, 30 years in
So
2008.
he should have known. He
Lordship,
would have known.
Lordship.
Yes. He says that, you see, there's a thing, no doubt, that when some things are not paid, when some things are paid due to a mistake on the part of the government, and where you have got no role to play, where there's no fraud on your part, where there's no misrepresentation on your part, then recovery should not be allowed, especially with regard to grade 3 and grade 4 officers, our employees, in terms of Rafiq Masih's case. In your case, what has happened? You were supposed to get your third MACP from 2018. Now you got it from 2013.
It is their fault, my lord.
No, but then you are a government servant. Is it? Didn't you know that you were supposed to get it after 30 years? Is it your case that you were not aware? You see, there is a thing called refixation. You see, when there's a refixation or fixation of salary, mistakes occur. But this is a case where a benefit is to be given to you for not being promoted at a certain time. And there are specific dates. So 2013, you are not entitled to that third MACP at all.
But Rafiq Masih is very clear, my lord. Since petitioner is a.
No, you please don't read only the last paragraph. You have got to read the
Yes, my lord,
paragraphs
but
in the middle also.
Recovery notice was given after the retirement of the petitioner, my lord. My lord, kindly.
When was the notice given?
Yes, my lord. My lord. 12th April 2019, my lord.
Then when did he retire?
31st December 2018, my lord.
Input notice given on 7/9/2018. Correction was done on 7/9/2018.
So that is not correct, my lord.
Excess roll of paid allowance. What is the amount? What is the amount?
It's around 3 lakhs. But Lordship, 24% were corrected on. With one, if we excuse one Lordship, other 23 will come Lordship. That's the difficulty. Other his case would have been dealt with exception Lordship, but 24% has been corrected by this input notice Lordship. That will Lordship will find at page 26 of the petition. Altogether 24% Lordship. Wrongly given, so we corrected that. Lordship. And rest of them,
First of all, it was not their fault.
that's true, Lordship.
Only thing is that they would have been aware that they were getting something
Deriving
that
the
they were not
benefits.
entitled to.
Deriving the benefits.
So let us see Rafiq Masih, which part of Rafiq Masih is favorable to you?
My lord, so far, group C or group D employee is sponsored, my lord, it cannot be accepted.
No, 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 no. You cannot read it as a whole. Let him. Give me Rafiq Masih.
Also haven't gone, sorry.
What is this? Both of you.
Rafiq Masih and Sam Babu
There is
Barma.
another case also. I think Burma.
Sam Babu Barma. Lord.
Burma's case is also there. Please come prepared. Don't.
After tomorrow. Lord.
There are some paragraphs. I know both of you are not hitting on those paragraphs. Yeah. List the matter after 2 days, 3 days on the pair of the parties. Please read those Shyam Babu Verma, Rafiq Masih in the middle. Yes,
The Nia, my lord. The respondent, my lord.
has the Supreme Court decided?
Yes, my lord. The Supreme Court has upheld the lower court order granting bail.
And how come they are not here? This person. Can you tell them to come?
My lord, and the connected one appeal was there that was withdrawn by the Nia, my lord. Yeah.
So the orders were passed by Justice Ajit Singh, I think. Division bench of this court.
My lord, earlier, my lord, the one was cancelled. my lord.
I mean, where is that order?
This, there is no order here, my lord, because we cancelled in a connected application. my lord.
Okay.
Because we granted bail by the same order, my lord. He went to the Supreme
That
Court,
was in 2018.
my lord. He went to the Supreme Court, that was stayed, and subsequently, my lord, now it has been. High Court order, the status of London lower court below has been upheld. In the connected appeal, my lord, criminal appeal
Yes,
150.
sir. What to do? Yes, this is with regard to those cases. Now, what is this other matter? This case, this order?
But I was criminal appeal 155, my lord.
Huh?
What criminal appeal 155, my lord. That was withdrawn by NIA because Supreme Court set aside the High Court order. my lord.
Okay, okay.
Same batch of bail orders, my lord. Everybody was granted bail. They came for cancellation, my lord. One went to the Supreme Court. That order is appealed to the lordship. my lord.
So they have withdrawn though.
Yes, my lord.
Now where is he? Can you call him?
Well, try and inform me.
Just call him, then we'll dispose of this matter.
Well,
Nothing survives it.
my lord.
Or someone. Yes,
My lord. In this case, I'm against the only, my lord, permanent alimony. And in that case, my lord, there is a nowadays, my lord, after that, there's Rajesh Bachchan Neha case. Both sides has to file a
fine
affidavit.
affidavit.
But here in this case, we file a affidavit, my lord. In court below, it was not being considered. Now, my lord, you lordship ask the both party to file a affidavit before the honorable court also.
You file affidavit, both of you?
As per that.
Neha versus, what is that?
Neha versus Rajesh.
Rajneesh. Neha versus Rajneesh.
2021 2 SCC.
Yeah.
So, my lord, I'm ready to file because already I have filed in court below, but here also I'll file. And let
No,
me
no,
file.
you have already filed in the court below, so why should you file again?
No, my lord, they have, whether they have filed or not, I don't know.
Have you filed the affidavit? In terms of the judgment of the apex court?
Assets and liabilities, lordship, both the parties file your lordship.
In the lower
And in
court.
the judgment that is discussed by your lordship.
Okay, let us see. Let us see the low court report.
Para 15, my lord. There is absolutely no discussion, my lord.
No, no, let us see your affidavit.
Oh, my lord. My affidavit, my lord, I have an ex.
You have it.
Yes.
At what page?
Affidavit. My- I'll- Hmm? Indexes.
Their affidavit, your lordship will find 62 at page 62.
62.
Their affidavit.
Your affidavit says nothing about your income.
My lord.
Your Miss S. Jahan, additional PP and Mr. H.R. Ahmed for respondent number 2, submit that they have received copies of the paper book. List the matter for hearing, usual course, after ensuring that paper book has been given to the legal aid counsel.
May it please the Lord. My lord, the order under review is at page 17. My lord, the policy provides that within a stipulated period, if some land are allotted to you, you cannot sell it to somebody else. The earlier council was unable to place it before the court.
What right of yours has been affected?
Well, it is a PIL, not a right. It's a PIL. We are the villagers of the nearby grazing land. And the grazing land has been allotted for private purpose. And my lord, it is a PIL, not a private adversary litigation.
It's a grazing land.
Grazing land, a grazing land for the villagers, which has been allotted to some industry, and the industry has within a stipulated beyond within 1-2 years, they have sold it to some other third party.
Without it being settled.
Not the settlement was there with them. They have sold it to somebody, which is prohibited.
No, no. It's not that. I think the government stand is that it had been allotted but not settled. That is your case. Your case is that it was allotted, but prior to settling it with
But the
those persons, yes.
My lord, maybe, either of those.
So they are differentiating between allotment and settlement, and they are saying that a person who has been allotted land, he can sell it. That's what you're saying, is it?
Worship, I received instruction regarding this case yesterday, Your Worship. Worship, may kindly give me 2 weeks time and file my affidavit. I received from the circle officer. And Your Worship, the premium was paid.
What is the?
Premium was
No,
paid,
that-
Your Worship. That after. it
No,
was-
no, you see, the issue is this. The issue is this. The issue is a person has been given
Yes, sir.
allotted land,
Yes, sir.
and that person now to have that name, to have that land settled in his name, he needs to be in possession of the same for 3 years,
Yes, sir.
correct?
Yes.
At least.
At least,
Yes.
yeah, so 3 years minimum. So prior to the 3-year period, that person has sold off the land.
Full of them.
Now, the grievance of the petitioners is that actually they are fighting this case for themselves, not for somebody else. So I do not know whether PIL will lie. That's a different issue. Now, their case is that that person could not have sold it because the land was not his. Because allotment, according to them, did not mean that it was his land. He was the owner of the land.
If your lordship, my lord, with your lordship permission,
May-
if your lordship take up the PL application at page 16, there is a Jamabandi copy where it was allotted to them, then it was settled, then they have sold it. Page
It was settled.
Yes, sir.
settled and
Then if it was settled, then what
no,
remains?
my lord. There is a prohibition under the land policy that after settlement for 15 years, you cannot sell it. It has been
2001.
given to you for particular purpose. You cannot sell it within 1-2 years to third party. But those are government land.
Let me see where you cannot sell it. Where does it?
The policy is there, Mama. The policies are there. Land policies are there. In 89, it was also there. In 2019 also it is there.
But one thing is basically your fight, you want the land for yourself.
No,
What
it
are
is
you?
a grazing land for the villagers. They graze their animals, cattle and others, they move around. But it's for the villagers. At page 16, your lordship will find that in Jamabandi surveyed village. Page 16 in the PL petition. It was allotted to JK Industries.
Was settled, Your Worship.
Huh?
It was settled, Your Worship, as per the paradise comments.
was
I have
settled?
received. Yes, Your Worship, the then Deputy Secretary to the.
Where is the law?
It is the land policy is there.
Where is that?
Land policy is cited in the order, Your Worship.
But here, if I can read it slowly, Malak.
Review petition.
2019, after settlement of land to a landless indigenous person mentioned above, the settlement owner shall have no right to
No,
transfer the
this
land.
land policy is of which year?
2019.
2019. And this land has been given in which year?
This is
2001.
2000, and when was it sold?
89. 89 is there. 89
89.
also.
Land policy is cited in the order, Your Lordship.
Then the 2019 land policy is not
2089 land policy also says
89
that-
years.
that such allotment shall stand cancelled if the land is not utilized for the specific purpose within 3 years of allotment.
Correct, but then now this is not allotment, this is now settlement. This has been settled.
And my lord, the allottee must utilize the land within 3 years of the allotment for special cultivation, failing which the allotment shall cancel. After expiry of 3 years of allotment, the land may be settled with the allottee provided the same that has been used for special cultivation. Such specific.
No, you see, that is a different issue. When it basically, I think that it basically says that an allottee cannot sell his land.
Still is there.
But then does it say that a settlement holder cannot sell his land?
My lord, here nothing has been listed like that.
That
But-
is their case. That is their case. Their case is that.
My lord,
since
they are
it-
not opposing to us. They are not opposing to our PIL. Virtually, it is in support of the government. Because it is a
I do
government
not know
land.
whether they.
And
they're-
under the government land, in a grazing land, it is prohibited under the Assam Land and Revenue Regulation. You cannot be settled with anybody.
Let us see that affidavit then. Let them file that affidavit.
Under the Land and Revenue Regulation, grazing land cannot be settled with private party. It's
Where
probably.
is that? Where is that?
It is there, my lord, in 18.
In the 89, in the 89,
18, my lord.
what does it say? Let's read.
Rule, my lord, 18.
Of the 89 regulations.
89.
What does it say?
My lord, it is, my lord, here it says that, my lord, that where any person enter possession of a government caste land, wasteland or estate, no person has acquired the right of proprietor, landlord or settlement holder or land and the previously which reserved road or roadside land or for the grazing of village cattle or other public purposes.
Just let us see this. Let me-
And they will be ejected forthwith, my lord, without notice.
Maybe let us.
Ejectment rule 18(2). No, I can't.
This is settlement rules, you know.
Huh?
This is a
Settlement rules.
Not the
18,
land policy.
not land policy.
Yes,
It is-
yes,
It is
Which one are you reading? 18?
18(2).
18.
18(2).
That is
When
regarding
such
action.
has any possession of government khas land.
That is regarding illegal encroachment. in
This is the
eviction.
encroachment. This has got nothing to do with your. Nothing to do. with-
Because, my lord, government land in any purpose cannot be settled as grazing land for any private
No.
purpose.
Government land they can always give. It is their right, it is their land.
But here our case was that within the short period, they have sold it to third party. That which is prohibited. They have to utilize it for their own purpose. And it is within 2 years.
Anyway, let them file the affidavit. Yes, Miss
And borderline.
N. Bordoloi.
N.
N. Bordoloi submits that the land which has been sold by whom, by Mr. By whom?
The private party, my lord.
By who's he? Respondent number
JK Industries.
JK Industries,
JK Industries, the worship.
has been sold by the respondent number,
5.
by the respondent number
In the
5,
review petition.
had respondent number 5
To the respondent number
Uh,
6 onward.
to the respondent number 6 onwards had been settled in the name of the respondent number 5 after the same had been allotted to the respondent number 5. As such, there was no bar for the respondent number 5 to have sold the land to the other respondents as they were settlement holders. Full stop. She submits that she may be given 2 weeks' time to file affidavit in opposition as she has received parawise comments. Full stop. Praise the Lord. This is the matter after 2 weeks. Huh?
From the circle office.
Parawise comments from the circle office. This is the matter after 2 weeks.
And DPO.
May I please look? Mapping.
Yes.
An application for declaration of the appellant as a juvenile. The report of special judge has come. And the last occasion, Lordship wanted the registry to give us copy to both of us, the copy of the special judge. Mr. D. Das was actually there on that day and the copy was perhaps served on him.
Who's
Yes,
Dida?
yes, he is the APP. I was not there. I was not there that
Okay.
time. So the copy perhaps is with D. Das. I've just seen the order. Otherwise, he has prepared the matter and on certain points. Otherwise, I have not,
You are not
otherwise,
prepared, so you want some time.
otherwise I have not seen the report. What
You want to see the report.
he is also contesting, I think.
No, report is in my favor.
Oh, is in his favor.
Report is in my favor. And I only because of that idea, occasion also Lordship pointed out that judgment. That whether admission register will be maintained will also. I have just prepared one note if you Lordship wants to favor, I can hand it over.
You see, first of all, where did your application, it is based on the transfer certificate,
That's
correct?
what I did. Yes, in
Now-
that case, Lordship, Honorable Apex Court where it is said that that will not be admissible because Lordship in that case, what happened, prosecution did not rely on that certificate. And during, after closure of prosecution witness, that headmaster was examined as CW1. So Honorable Apex Court said, when the prosecution is not relying on that, court cannot go on that aspect context, it was said, Lordship, in my understanding.
I don't.
And I have mentioned some.
You see, there
judgments
is a
also.
judgment also that I have.
Yes, I have also
You-
mentioned in my note regarding some judgment, Lordship, where also it is said that entering the admission register, His
Admission register is okay, but yours is not an admission register. Where did you first go to school?
no, before this honorable court, I have placed that admission that school living certificate. Subsequently, during inquiry, that admission register was examined, the headmaster was examined, and thereafter the inquiry report was submitted before this honorable court. So the finding is based on the admission register.
But the law, as I know, the maker of that
Has to be.
stipulation has to be examined
Yes, he was
and
examined.
cross-examined.
He was examined.
No, more than that.
Huh.
Where did you first attend school?
Lordship, 2000,
Which school? Where? Because you're relying upon a transfer certificate.
Lordship. Just an question, sir.
Now, these admission registers are not provided under rule section 94. So if he doesn't have those two other documents, date of birth by the school or the municipal corporation, then ossification test would be the only option. Of course, I've not seen the report, but in absence of those two certificates, ossification, not admission register or something else.
So regarding that, Lordship, I have just prepared and I have quoted the relevant paragraphs. I am also having those judgments where it is said entry in the admission register is admissible for determining the age of a juvenile, Lordship.
No, it's an admission register, but were you admitted to this school in which class were you admitted?
Yes, that is in their Lordship. I was in there in the year 2009. I was admitted in 2000.
For bail.
Then I'll file my objection because this has come up new, I think.
Yes, sir.
But this is already fixed for hearing, the main matter. 22.
What is this case about? Section 6 of the POCSO Act.
Section 6.
Ultimately, your lordship knows that if they are acquainted with the voice, that and they have heard,
No, so if they're acquainted with the voice, what happens?
generally that is a corroborative evidence.
Now,
to
where
take into
is
account.
there any citation?
That the trial judge himself has recorded that decision in the, this is,
For example, I have.
right. That decision is that of course here the eyewitness itself is there. This is a case otherwise of an eyewitness, and the eyewitness is not someone who's related. So independent eyewitness.
It is nobody's case that he's an interested
No, that can be. Well, this is Honorable Supreme Court's
But what was the
decision.
motive? What was the motive?
That decision of voice identification is AI 2018,
Just a minute. AIR
2018. Supreme Court, page 4020, paragraph 16.
voice recognition.
So it says that if one is aware and that person says that he has heard so and so's voice, then that will be taken as. It says, thus from the above cases, we may cull out the principle that identification from the voice of the accused may be possible if there is evidence to show that the witness was sufficiently acquainted with the accused in order to recognize him or her by voice.
So AIR 2018
18,
SC 4020.
my lord. And then, of course, your lordship is well aware about the eyewitnesses. If they are reliable, even if it's one, your lordship can solely act upon it. There is nothing here. Apparently, PW4, PW6, all their 164s are also there, which they've exhibited. And it is almost the same. There is no.
So there is no discrepancy between their statements under 161,
My lord.
164,
My lord.
and there was no confessional statement made by the.
No, because the accused, he denies. In fact, he has not even explained because there are too many incriminating statements that has come from his own son. Now, accused does not explain
Why, what was he carrying or where did he go? Where did he come from? No explanation. He simply denies everything. He says it's all false. That's his version. He was heard by PW 5, PW 7. They both are again neighbors. They're all independent.
What is the, what was the motive?
The motive is not, one cannot say from the records.
Cannot discern
because,
anything from it.
it comes from the informant's evidence, who's PW2, with whom the deceased was staying, my lord. Deceased is of 28 years, and he always stayed with PW2. Now, PW2 says that they were friends, accused and the deceased. They used to consume liquor, and sometimes he goes and stays in accused house also. So, it looks like they were friends. And what PW6, he says when he was coming, he saw the accused telling the victim that you go, and victim was lying on the ground. The accused had a da and a bamboo stick, and in cross he says that he saw him hitting. And this he also
No,
maintains
in
his
the examination in chief. he said.
correct. And in cross examination, he says he saw him hitting. That part he says in cross. Be that as it may, it is in the court. He has said that, and in his 164 also he said, which is corroborating.
What about 313?
313, just a general
Denial.
denial, nothing else.
So who gave 164? Just give me the,
160 PW 3, 4, 5, 6, 7, all of them. PW 4, the son of accused, his 164, your lordship will find at page 60. PW 5, your
just
lordship,
a minute, PW3, you'll find that.
PW 3 at page 57.
Ah.
PW 4 at page 60.
Ah.
PW 5 at page 63. PW 6, the eyewitness at page 65. And PW 7 at page 68. And they all have confirmed that in their in the court.
And was the weapon seized?
Well, that was not seized. IO's evidence is PW8. That weapon is not seized. There's no explanation about that. The accused had gone because accused son, who is PW4, said that he had come back after some time. And when he had gone out, he had an object in his hand. What is that object? He doesn't mention. While coming back, he has just come back.
Doctor's report?
Doctor's report is PW1. Injuries in brain, sharp weapon, back of the head.
Eyewitness saw him with a machete
Yeah.
and a
Yes,
lathi.
yes, I mentioned.
Mm. So has to be a sharp weapon machete.
Now,
Yes.
he may have thrown that somewhere because that is not, anyway, that is the police ought to have made an effort. What happened, we don't know. And this, even in the sketch map, I was trying to figure out where exactly this happened, because PW5 said he was inside in their courtyard. From there, they could hear. So at one place, it is said about one particular person, but that person is otherwise not examined. They were all sitting at his courtyard and in front of his courtyard. Probably the incident happened. In the sketch map, they say they don't identify that exactly whose houses were those. But anyway, these are minor. I don't want to unnecessarily put
Yes.
much stresses there, but these are minor.
Yes, anything?
Nothing he has done from both the sides. PW6 being the only eyewitness he had seen, he had narrated. And the person that he had informed, they have also said that yes, we were informed by him.
Yes,
Voice identification,
that is
those were there.
1994.
So he said, I informed so and so, and then he also said, voice identification is there. And then 3 and 4 has also seen him going out, no?
Yes.
Corroborated by medical evidence. And motive, what did you say on motive? Yes,
Nothing otherwise from record.
yes, what?
So that's right.
So basically, were they drunk or something? No.
That I don't think the postmortem report doesn't indicate anything, and none of the witness said anything. But yes, PW2 said that they generally occasionally used to consume liquor.
But PW6 said that he heard the accused saying, go from there. So
Yes,
why?
in cross, my lord, PW2 have said, victims sometimes even did not, deceased Hema Soikia sometimes even did not return for 2-3 days. He used to stay with various people and sometimes even with the accused after consuming liquor. So from there, I gather that they are friends and they used to consume liquor. But in
So he was a
postmortem-
lover of practice.
That is there with everyone. But nothing to brush aside PW6's statement.
if PW6 did not say that he saw during cross, then I would have had a case because what he said that he saw initially was that he heard the accused saying, go away to the victim. He didn't see the accused hitting, but then in cross he said he saw. So that clarifies, therefore nothing remains. And on that sole eyewitness, there's one decision, if your lordship wants, I
Yeah,
can,
yeah.
1994, volume 4 SSC at page 549.
1994, volume 4, SEC.
At page 549, relevant paragraphs will be 12 and 31. I may just read 12 shortly for your lordship. In the said report, this court further pointed out that generally speaking, oral testimony may be classified into 3 categories, namely 1, wholly reliable, 2, wholly unreliable, and 3, neither wholly reliable nor wholly unreliable. So far as the first category of proof is concerned, the courts have no difficulty in coming to its conclusion either way. That is to say, it may convict or may acquit on the testimony of the single witness if his testimony is found to be above approach or suspicion of interestedness, incompetence, or subordination. So here, my lord, this guy, PW6 is otherwise a neighbor. There is no reason for him to make a, at least from records, I don't see him to having any reason to unnecessarily claim it to be accused. And whatever he said ultimately has been corroborated by the other witnesses.
If it at all can be brought down, because PW7 and others have also said they heard the voice of the accused saying, ja, ja, go away. So he didn't have the intention to kill him outrightly, but perhaps there was something. But as far as the records are concerned, I don't find that material so many materials whether to show there was any quarrel or anything.
Except that go
Provocation.
away.
But
So under 304. But
because it seems that he didn't have the intention to kill or something, but because he was saying, he was telling him to go away from that place. But in the FIR, I think that quarrel part is perhaps there.
No, FIR,
no?
nothing is there.
Nothing is there.
FIR is a suspicious condition. He was found multiple injury. He
Hmm.
was found dead with multiple injuries and suspicious conditions at Suez.
But will any of the exceptions come into play?
That is what I'm trying to bring, although
Difficult.
not many words are there, difficult.
Because,
But what
injury is in the head.
Head, vital portion. PW7 said at that time we heard someone shouting Jaja, the voice was of Aniram Pangeng. We went to the place and saw the dead body lying in the place.
In
And-
case the accused would have explained something, we could have understood what happened because he clearly had 2
Because
different
this is a Arunachali, I think, Panging.
Panging.
Pangeng, perhaps, yes. Even 6 was saying he was telling Hema to go away from there immediately. Was having a bamboo stick and a dao, was lying. I immediately left the place.
It appears that I don't know, subject to correction, maybe the deceased was quite a
Provoking
nuisance.
him.
Might be a nuisance.
Might be a
If he sleeps in people's houses for 2-3 nights, doesn't go home.
Mhm.
That doesn't seem to be, a very normal behavior. Seems that he's there's a vela type of person, just going and enjoying and just not caring about anything.
People want to avoid him. And
Yes,
so
avoid.
he's going saying, go. Or
Or they're fed up of him.
fed up of his
Could be.
behavior.
Fed up of him.
Could be.
Could be,
So-
but then how do we how do we attract the exceptions?
Legally. 5 had also heard voice of the accused outside. Went out, I saw Hema Soikia bleeding. He was inside the house and. বহান্তি হৈছিলে।
Very difficult.
Because since PW5 and the PW7 have heard, they don't even say that they heard a quarrel or they heard the deceased provoking. Those have not come. They only heard the accused.
And no explanation given by mandatory.
Correct. He had an opportunity. He could have said that the deceased was provoking or deceased was quarreling and the
Or the deceased
something.
overstayed his
correct.
welcome or
He
something.
could
like
have
that.
given some explanation. Without that explanation, it would be difficult to assume something.
These are the advices of the lawyers perhaps, and they said that we don't know. It can happen. But for this one has to be inside for his entire life.
That is what, that is what.
Perhaps he was not bailed out also.
And you should keep in mind also sometimes, the maybe, the kind of persons they are. He's from the hills.
Oh, yes.
Usually they are not very extrovert and they don't say many things.
And they are little angered also.
They are more inward looking than outward. So, so, I mean,
Mm. He was perhaps.
so
inside-
maybe we don't know the real story.
Mm.
Well, I'll just read PW 164 for a moment, Bala.
Yes,
Uh,
page,
page 65.
yes.
I am married. Page 65.
Yes,
I am Shri Mukesh Mili and I am 17 years old. Around 8:30, 8:40 PM on 6/12/17, while I was returning from shop, I saw Aniram Panging assaulting Hema Soikia in front of our house. As after assaulting Hema Soikia, Aniram said to me, "Go away from here." After that, I came home. He said that the accuser told him to go away. My brother, PW5, PW7, and Poran Panging were sitting in the courtyard of our house. They said that they too heard the scream. After that, we went there with a torch and saw that the dead body of so-and-so was lying there. Thereafter, we informed so-and-so, came to the police and so-and-so. But why I thought I will read this, because in his 164, he doesn't mention about the dao and the lathi. However, in court, he specifically mentioned both these two weapons, which he says he saw in the hand. That is it could be an omission. Sometimes an omission can also become a contradiction.
but was he confronted with that? Fact?
No, he was not. He was not. No, once I'll just reconfirm it at page 19.
It's not.
Page 19. I think he was. Page 19, during cross, I saw so-and-so beating with the bamboo stick. I saw the incident from a distance of about 100 meters. It was dark at that time. There were trees by the side of the road. I heard Aniram Panging asking the victim, Hema Soikia, to leave the place. There he said about him, here he said this, I did not go near the place of occurrence at that time. It is not a fact that I did not know who being beaten by Aniram at that time. After some time, when we went to the place of occurrence, I noticed injury on the head of Hema Soikia. It is not a fact that I did not see Aniram beating Hema Soikia. It is not a fact that I presume the person to be Aniram, hearing the voice. I did not state in my statement before the court that I noticed injury in the head of Hema Soikia, as the same was not asked to me. It is not a fact that I did not see any injury. But the weapons, that was not asked. The rest.
No, but then where does it say that he used the doubt?
My lord, here, in the evidence, he says, I saw Aniram Panging beating Hema Soikia. He was telling Hema Soikia to go from there immediately. Aniram Panging was having a bamboo stick and a dao in his hand at that time. And in cross, he says he saw Aniram beating Hema Soikia with the bamboo stick.
So the Dow was not used.
Maybe,
Dow was not used.
maybe.
But let us see the doctor's evidence then.
Yes, that PW1, your lordship will find at page 9.
Yes.
Page 9, injury, your lordship will find external. The next page, 5 numbers of incised wound, posterior part of the scalp, fracture of the scalp. Then brain and spinal cord are congested. There's bleeding on the posterior jaw. Opinion, in my opinion, the cause of death is due to coma as a result of injury to brain.
You see, there's no cut marks.
And during cross, my lord, your lordship will find in the next page,
Yes.
the weapon by which the injuries were inflicted was a sharp weapon.
That was an opinion only, but otherwise.
Anyway, I'm pointing
fracture
it out.
Fracture of the skull. So fracture of the skull can be
Bamboo-
by a big stick or bamboo.
No, you see, whether there was any cut wound, any.
No.
That is not
Fracture
there.
of the skull bone and
Hmm.
bleeding to the
Bleeding
brain
is
and
there.
spinal cord. is
Posterior
fantastic.
lobe of the brain, that is inside.
The lobe of the brain. And some mouth bleeding, no?
Mouth bleeding.
There is bleeding found on the
Abdomen.
mouth cavity.
Mouth cavity is the mouth, that is, that does not indicate anything. You see, if you are hit with a sharp weapon, then
There
there'll
could
be
have
a
been a
cut.
cut.
There has to be a wound somewhere.
I think it is the bamboo
Open
stick
wound.
which must have been
Ah.
used. Because even for me at that time, I was also thinking it's a little bit of exaggeration for a person to say he'd seen someone carrying both. Why would he have a dao and a bamboo stick in his hand?
And 8:30 at night.
Correct. He will use one thing.
You cannot, it's very
Correct. It's
difficult.
very difficult to use both.
And then you do it, the force won't be there.
Generally, that
If
would
you,
be
if
difficult.
you have
Yes,
ever hit somebody with a
correct.
bamboo.
And moreover, here now in PW6 does not say about the weapons. It's at his during his 164. During court, he says, and in cross, he specifies he saw him hitting with the bamboo stick. So I think it will be safe to assume that it is only the bamboo stick. Fact that the weapon is not seized also.
Bamboo also not seized.
No, no. Criminal and liner.
Okay, 1 o'clock. So we'll not the same. We'll dictate at 2. Little bit of dictation at 2 and then most probably CAV after that.
Oh, that part had much.
CAV, I think. Because we have to look
Correct, the evidence.
if something can be done,
Yes.
because
You-
if some other provision can be attracted or.
Because he was beating, so 326 can be attracted.
But then it resulted in death.
But then there are so many decisions Supreme Court has converted into 326, even if it has resulted in death. After few days, but this is instantaneous death, but seeing that nobody had seen him giving a blow with the dao, he said, I saw him beating.
Beating with the bamboo
Beating.
stick. No, he
If-
said PW6 said beating with the bamboo stick.
No, beating with a bamboo stick and giving a blow with a dao is different. So here,
Dao probably was not there. Dao is
Beating
something is an
means,
exaggeration.
beating is like beating someone. So it can be in a way converted.
No, we'll have to see again the injury sustained and which parts of the body and how many,
How many?
because if it was quite a number,
Correct. 5 numbers it says.
and then
No?
it'll be difficult.
No, fifth column, Nikki, 5 numbers. Hey, I actually postmortem report to something. I'll leave it.
Report to
Fifth
5
column,
numbers of in size.
correct.
5 numbers.
51.
Inside, okay, inside.
Yeah, 5 numbers. Page 52, postmortem. 5 numbers incise wound on peripheral area of skull. 1 to 1.5 inch of post, skull bone. Membrane congested. Then brain and spinal cord congested.
Inside wound,
bleeding on-
inside wound would be cutting wound.
Inside
Incise
can
is
be there
cutting,
sometimes
huh?
blunt weapon also.
Maybe
There are
because of the
judgments.
incised wound, the opinion of the doctor is using of a sharp weapon.
But 5 numbers, normally what the doctor says first is this, second is this, but here it's in totality, he said 5 numbers.
And at page 55, more detailed description. A stout male dead body rigomatous, 5 numbers of incised wounds found on post part of head skull. 1.1 to 1.5 inch long of the post skull bone noticed. There was bleeding inside the midbrain and postbrain lobes. Abrasion of nose and face seen bleeding. Above all, the sign were antemortem in nature. In my opinion, the cause of death of disease is due to coma as a result of injury to the brain.
He was there inside the jail since day 1,
That is
Since-
since,
the day of arrest.
that is when. 2017.
2000. Yes, he was inside.
December 17.
Hmm.
So he's been there for nearly 6 years.
That's all he told us.
Well, he's taken the life of a person.
Yes, taken a life.
We'll have to see.
But in the causal, it is shown 3 years is inside.
Maybe he was a bail.
No, they find it.
Go ahead and record.
Otherwise, he was produced from jail custody. Accused was before me, after police remand. Oh, no, no.
Okay, we'll take it up at
Madam.
2. Accordingly, we convict the appellant under section 365 IPC and sentence him to undergo rigorous imprisonment for 6 years with a fine of rupees 5,000 in default to suffer SI for 2 months. Period of imprisonment already undergone as UTP and as a convict shall be set off.
Couldn't get anything more than what we had just said. He was, of course, inside the jail since the day of his arrest. So 6 years.
80, 80, 80,
80.
80.
Yes.
Bail petition of a is fixed for hearing today. Meanwhile, bail petition number is also filed subsequently, and all three bail matters relates to present same case. I'm inclined to.
We are interested in which case? 119, 120, 121, which one?
Uh,
In page 80.
Yeah, his bail petition number is, your lordship.
121 most probably lordship. Chronological.
Most probably cannot do, Mr. Counsel, please be sure.
It is not
Yeah,
there.
quite true.
Huh?
It is not there, madam. But it is 190.
No, this case that we're dealing in right now, it pertains to which bail petition?
That only page 80, there are three numbers there.
You don't know that. You don't know the facts of your case.
The record also is not there.
What do you mean?
All three are numbered together. Madam.
No, Mr. Counsel, one thing is that bail has been granted to you.
Bail is-
They have challenged the bail. Now bail has been granted to you in which case? You don't even know that. Why should we take it up when you're not prepared? You're on the most simplest. Yes, bail was granted to you in which case? 119, 120, 121, which one?
So 121.
So how do you say that?
Because
121, my lord.
Huh?
121.
121.
May I just come to page 29. Okay, listen. Page 29.
Yes.
Page 29. Set aside the impute order date choice as the past in the appropriate.
121. Okay.
121. Now, what is the pen, my lord? He was working, actually, he was working as just. He was working as directorate of working in the director of urban development, government of
It
Nagaland.
cannot be in the
Yes.
director of, it has to be in the directorate of.
As
Either he's the
Executive-
director or he's not the
as
director.
executive engineer. Executive engineer DDO. And he is arranged as case number 13 in the supplementary search sheet. Because Malad, when this bail application was taken, Malad, at a time, investigation was going on, and the first search sheet that was filed against only 3 accused persons.
How
That
much?
was
How many,
three. First search sheet was filed on 31/5.
how many persons
Malad, all total 13%.
in the first charge sheet?
No, in the first search sheet, 3%. 3%. Then in the
Second charge sheet
Second charge sheet.
supplementary,
from 7, accused number 7 to 13, then he is accused number 13.
okay. 7 to 13.
No, so just 1 minute, I'm just kindly just. Thereafter, on supplementary charge sheet, accused of 4, 5, 6, 7, 8, from 4 to 13. 4 to 13.
Huh? 4 to 13.
4 to 13. The the allegation is that Palas, that as he was working as executive engineer, Palas, he was providing funds to payment to NSCNK and other terrorist organizations doing
From where?
from the
From his own money?
from the government fund that
From
is
government.
allotted to the government fund. That is the allegation, madam. If you want to see the charge sheet, allegation. It's not there.
Yes.
If you want to see the allegation inside. It is not 13. Supplementary search.
Supplementary charge sheet filed on,
That was filed on. The first search sheet was filed on 25/1/17, and the supplementary search sheet was filed on 31/8/18, 31/5/18.
31/5/18, and
18.
the first charge sheet filed on.
First search was 25/1/17.
So you see, now when you read this charge sheet, the extortion letters have been given to this person, to the petitioner, to the respondent. And the respondent had endorsed it to another person, to the DAO. And the payment was made by the DAO. But it was under threat. It was not voluntarily given. It was an extortion letter. Then only problem is this court should have given some reasoning. No reasoning at all.
Of course, this threat, etc., that will go in the trial.
Naturally.
That will.
But what do you say with regard to similar matters where the Supreme Court has set aside the division bench judgment of this court
I've seen that.
on that ground? And trial has started now?
Yes.
Trial has started, probably?
Yes.
Has trial started or not? Has witnesses been examined?
I'm not aware. Sorry.
They are not absconding?
No.
Then
They've got
And
7 months.
they were granted bail in 2018.
18.
What is that? now?
And Supreme Court judgment is to on score 1, a criminal appeal number 418/2019. That was
This is how many? This is one appeal only, huh? One appeal.
One appeal.
Okay, right. Heard Mr.
DK.
D.K. Das,
Decade.
Learned Senior Counsel, assisted by Miss
G.D. Chaudhary.
G.D. Chaudhary, appearing for the NIA. Also heard Mr.
And Mahajan.
N. Mahajan.
Right.
N. Mahajan appearing for the respondent.
One.
This appeal has been filed under section 21(4) of the National Investigation Agency Act, 2008. Hereinafter referred to as the 2008 Act, against the order dated 28/3/2018, passed by the Court of the Special Judge, NIA, Nagaland, Dimapur, in criminal number 121/18, arising out of RC 1/16/NIA/GUW, page 80 of the. Actually, one thing before that, the Supreme Court judgment is with regard to which of these criminal cases?
The 3 other accused persons and my lord, 119, my lord.
119. This is actually 119.
My lord.
And what happened to 120?
120 is that, my lord, a criminal 155, my lord, withdrawn by Niyam.
Withdrawn. Why?
Because Supreme Court set aside the High Court order, my lord, they withdrew, my lord.
Okay. No, acha. No, but 119 was not, 119 was challenged or not? before the
119 was challenged in the High Court. High Court set aside the order, my lord. He went to the Supreme Court. Supreme Court then upheld the lower court order, my lord.
Okay, I know. And what about 120?
120, my lord, they challenged the order, my lord. Subsequently, since the Supreme Court set
At
aside
119,
120, my lord,
120.
since Supreme Court set aside 119 order, my lord, they withdrew 120.
Okay, okay.
120 was numbered as
No,
criminal.
but then 120, how could they challenge in 120? That means 120 was not disposed of by the court,
No,
by the High Court.
no.
So how did they go to Supreme Court challenging what?
119 they went, my lord.
119, they what 120?
120 was in the High Court, my lord. That is
High Court.
criminal appeal 1.
Acha, but because of the Supreme Court judgment in 119, they withdrew 120.
They withdrew 120.
So why don't you withdraw 120 or this one also?
120 was criminal appeal 155, my lord, placed the order.
155?
In the High Court was numbered as criminal appeal 155 against the Ladakh lower court order.
Okay, yeah. No, why did they withdraw? If they withdraw this, why not they withdraw this? That's what I'm thinking. Right. Next para. The case of the NIA is that the respondent who was working in the Directorate of Urban Development, the Government of Nagaland as executive engineer / DDO had directed the DDO, had directed the DO of the said directorate to make payments of money to the NSCNK and other underground factions due to the request letters sent by the underground faction to the directorate. Next para. The learned counsel for the appellant submits that the bail that bail was granted to the respondent herein by the common order dated 28/3/2018 passed in criminal number 119/18, 120/18 and 121/18. Though for disposal of the present appeal, the case pertaining to the respondent is criminal number 121/18. Next para. The learned senior counsel for the NIA submits that the order dated 28/3/2018 passed by the Court of the Special Judge NIA Nagaland Dimapur had been set aside by this court by order dated 3/9/2018 passed in criminal case number passed in criminal appeal number 139/2008. He submits that a challenge was made by the person in criminal number 119/2018 against the order dated 3/9/2018 passed in criminal appeal number 139/2018 before the Supreme Court. the Supreme Court thereafter disposed of the appeal titled, out here, titled, yeah, it's here. Also, to 2023 SCC Online SC 445, by which the judgment of this court, by which the order dated 3/9/2018 passed by this court in criminal appeal 139/2018 was set aside. Next para. The learned senior counsel for the NIA submits that though the learned Supreme Court has that though the Supreme Court has set aside the division bench judgment of this court and upheld, has it upheld? Not said upheld.
Not sensible.
Has just set aside the division bench judgment of this court passed in criminal appeal 139/2018. The facts of the case show that the respondent having admitted, correct? They admitted. Did they admit? Did they admit paying it to the underground, the money?
In 161 statement. That they were
The,
forced
the,
to-
the, the respondent having admitted to paying the underground faction in their 161 CRPC statement,
in para 11 of that Supreme Court order.
comma. There is a prima facie material to connect the respondent with the crime in question. Comma, that is under what section have they been charged?
I have this.
Comma, that is section
Sections 39 and 40 of the Unlawful Activities Prevention Act, my lord.
section 39 and 40 of the
Unlawful UAPA, my lord,
UA and P Act
UAPA 1967.
1967. The problem is, in this case, there is no discussion by the special court at all.
My lord, but same co-accused, my lord, that G Ikuto, my lord, page 80, my lord. There's also, he was also, my lord, I got to set aside the order, my lord.
Next. The learned senior counsel thus prays that the order dated 28/3/2018 passed in criminal number 121/2018 should be set aside. Correct? Next. Mr. M. Mahajan,
N Mahajan.
N. Mahajan, learned counsel for the respondent, comma, on the other hand, submits that the petitioner, no, that the respondent herein is similarly situated as the appellant in so supra, case Sato Supra. As such, no, further, the Supreme Court had set aside the order dated 3/9/2018 passed by this court in criminal appeal 139/2019, 18, which had set aside the order dated 28/3/2018 passed in three bail applications, one of them being the respondent's bail application. And the bail application of that K, so Chris Spencer, this one. So he submits that in view of the above, the Supreme Court decision would also cover the case of the petition, the respondent hearing. And accordingly, the bail granted to the respondent should not be interfered with. We have heard the learned counsels for the parties. The facts of the case show that this K, show that K, then Mr. Sanctum Chuba. And the petitioner had filed 3 bail petitions. That is criminal number 11918, 120/18 and 121/18 before the court of the special judge NIA, Nagaland, Dimapur. In view of they being charged under section 39 and 40 of the UNP Act 1967 on the charge of funding, on the charge of what? On the charge of
Providing.
Huh?
Providing.
On the charge of providing funds
To the terrorist.
to the underground factions. This court, no. The bail granted, the bail was thereafter granted to all the above 3 persons by the court of the special judge NIA, wide order dated 28/3/2018. The bail granted to Mr. K, while the order dated 28/3/2018 passed in criminal number 119/18 was challenged by way of criminal appeal 1115, was challenged by way of, was challenged by way of criminal appeal 139/2018. This court, wide order dated 3/9/2018, disposed of criminal appeal 139/2018 by setting aside the order dated 28/3/2018 and cancelled the bail of Shri K, Mr. K. Next para. Mr. K thereafter went to the Supreme Court, and the Supreme Court wide the Supreme Court wide its order dated 12/4/2023 passed in so Supra, case Supra, dismissed. No, set aside. The order dated 3/9/2018 passed in Criminal Appeal 139/2018. On the ground that the learned special judge had distinguished cases of persons who had indulged in extortion for furthering the activities of the underground organization and persons like Mr. K, who were government servants and compelled to contribute the demands made by the underground organization. The Supreme Court thereafter held that it cannot be said that the prima facie opinion expressed by the learned special court could be said to be perverse or impossible at the time of granting bail to Mr. K and to Mr. K. To stop. It further held that interference by an appellate court, and particularly in a matter where liberty granted to a citizen was being taken away, would be warranted only in the event the view taken by the learned trial court was either perverse or impossible. Next paragraph. Thereafter, by the judgment passed by the apex court in case as a supra, the Mr. K has continued to enjoy the bail granted to him by the order dated 28/3/2018 passed in criminal number 119/18, 120/18 and 121/18. Next paragraph. An order dated 22/5/23 passed in Criminal Appeal 155/2018 has been submitted to this court, wherein it shows that the NIA has withdrawn the criminal appeal filed against the order dated 28/3/18 passed in criminal number 120/18. Is this correct?
No.
How do we know this? There's nothing stated here.
Thing is stated, but Sanctum Chuba is there, Manu. Versus Sanctum Chuba.
Full stop. Next para. Next para. The above being said, it is clear that the judgment of the it is clear that the respondent here is similarly situated as Mr. K, whose case has been decided by the Supreme Court in K. Senso Supra. The respondent, the supplementary charge sheet filed by the NIA against the respondent on 31/5/2018 shows that the NIA had recovered many incriminating documents relating to payments made to the NSCNK and other terrorist organizations. Full stop. The request letters which were served by the underground to the Directorate of Urban Development, Government of Nagaland, showed that the respondent had endorsed the same to the DAO, to the DAO, that is Sangtem Chuba, who was the person granted bail in criminal number 120/2018. Further, the appeal against the bail granted to Sangtem Chuba had been withdrawn by order dated 22/5/2023, passed in criminal appeal 11155/2018. Next paragraph. In view of the facts stated above, it is quite apparent that the petitioner is similar, the respondent is similarly situated as Mr. K. And Mr. Sangtem Chuba. Full stop. Though we are aware that bail can only be granted under section 43 bracket 5 of the UAP Act 1967. We find that the bail granted by the learned special judge has been upheld in respect of Mr. K. by K. Supra. Further, next para. It is also clear that though the respondent has been on bail since 28/3/2018, there has been no, the respondent has not absconded even after 5 years. Further, the case against the respondent is at the trial stage, as charge sheet has already been filed against the respondent and charge framed or not? Charge framed or not?
Just frame.
And charge has been framed against the respondent. In view of the reasons stated above, we do not find any ground to interfere with the impugned order dated page 80. The impugned order dated 28/3/2018, passed in criminal number 121/2018. The appeal is accordingly dismissed. I think there's no scope left, I think. Yes, Really? Oh, death.
Lordship, no? Perhaps for an interim day. Production is one thing. Ajit, IA number 730. Ajit, production is one.
Where is the death certificate?
Lordship, the death certificate is at page 9, translated and typed copy at page 9 and the original at page 10. Issued by the governor of that particular village. Yes.
How old was she?
She was around 65 years. That is what it's not reflected here. That is what they say.
When did she die? Yesterday?
Yesterday. It's written there,
So
reflected that
you are asking for how long?
Lordship, just 15 days. Lordship, the cremation has been held just a few, because the body could not be kept. It started decomposing. Yesterday evening, she passed away. 15 days to complete the last rituals. Just 15 days.
I have to consult my sister on this.
Shraddha otherwise takes place, perhaps they are Hindus, no?
Hindus, it's a 13 days.
13th
That is
day.
what I told, 13 days the Shraddha. After that, there are some more ritual. They have to immerse the ashes and all that. That is why we are 15 days, everything will be over.
389 application is otherwise pending. I'll file my
Otherwise, it's
objection to
pending.
that. This is again an interim.
And this is because of the development which took place yesterday.
So we'll give you 3 days and then you come in, then you ask again for Shraddha.
Lordship, he is the eldest in the family, we have stated, and there are certain rituals which he has to perform. Otherwise, Lordship, he was supposed to do the cremation also, but we were late of it by.
Cremation already done.
Yes, a few hours back, body could not be kept. Just a couple of hours back, that is what they from, they could not keep the body.
Something I'm not well versed in this line, so I'll have to ask.
He's the eldest son. He is supposed to do as per their custom. They are from the missing. Only even as your lordship knows, as per Hindu tradition, the eldest who is supposed to conduct all the rituals, but because the body was decomposing, it could not be kept more than beyond 12 hours. That is why cremation had to be done. But the other rituals he has to do those.
What are the other rituals?
Lordship, there are so many rituals. I cannot explain. They have to give the pindas and all that. And missing community, they've got some other, they've other special rituals of their own. I do not specifically.
Even I'm not aware. Perhaps the main things were already done by one of the son.
No. You cannot say main thing. You cannot say main thing. That is, cremation is just one part, and the rest follows there up to the Shraddha ceremony. Sorry.
That's a report only 2-3 days, that is.
Okay, we'll allow you for 3 days.
Lordship, 3 days, it will be, even the Supreme Court Lordship, even the Supreme Court Lordship in similar cases have allowed applications in this manner for performing the last rituals, at least for completing the whole thing. Lordship, even the other high courts.
You see, the problem is, I don't know, I need help on this score. Something I'm not very familiar with.
Understand.
The Hindu rituals, the rituals that you follow. So that's why you'll have to guide me. What is to be done? What do you think?
Till 13th day, perhaps they will have some pujas or something that
Yes,
I'm
that
not
is what-
aware of.
Yes, that is what is.
But he can again come back on 13th or Shraddha and again she can make an
No.
application, but
But we,
No, up to the Shraddha ceremony.
Ceremony and 10 days. That is.
No, till on the 13th day, they'll be having the Shraddha on the 13th day.
13 days.
13th
At
day.
10 days, one.
Loha.
Doha.
That is Loha, shave of their,
That is 10.
yes, shave the head, hair and
10 days,
everything.
13 days. I think
And leave it to your lordship. And it
Lordship,
can be either 10,
every
11
day
days.
there are
or-
some rituals to be performed. That is what I am told. Lordship, can it be this way?
The problem is that you are told, but you're not telling us.
Yes, what I'll do is, as your lordship has, it has fallen for your lordship, 5 days lordship. And after, I'll file an affidavit stating all the rituals that is to be undertaken
Now
by
so
him
you'll
every
have
day.
1001 rituals.
I'll file an affidavit because even I am not aware what, we have to file the.
You're not aware and you're trying to.
No, no,
So it's a classic case of one blind man leading another. She doesn't know and she's trying to tell us what
No,
to
no.
do.
Lordship, as per our Hindu tradition, Lordship, up to the 11th day, until the Shraddha ceremony is held, if the sons, Lordship, who has to undertake the rituals, they are not allowed to leave the home. That is probably my Lord Justice Nandi should be aware of that.
That I'm
They
aware.
are not even
Perhaps they'll have to
allowed to
stay
leave the home.
indoors
They have to
or
stay indoors. That is one belief.
cannot
And
sleep
these,
on bed.
Lordship, these are
those
missing
things.
community, they are from the tribal people. Lordship, they have
Okay,
certain.
we'll give you 2 weeks. You have paid for 15 days.
Lordship.
We're minusing 1 day.
Yes, Lordship.
Okay, right. Heard Miss D. Borgohain, learned counsel for the applicant, who submits that the petitioner's, the mother,
Mother.
the applicant's mother.
This is not different.
No, village headman he has issued. Village headman to death certificate from
By the village.
Yes.
Pura.
Yes, by the village headman, that is the sole authority. He is the government Gaon Pradhan.
Okay.
Nowadays, he is
Okay,
referred to as
okay,
Gaon
okay,
Pradhan.
okay. Who submits that the applicant's mother expired yesterday, that is 208/2023.
Down below, it's reflected that there is a statement there that the Rajiv Pegu is the eldest son of the deceased. There is a statement also. He is certified also.
We'll list it after tomorrow, madam. You file an affidavit clarifying.
Lordship, what?
You file an affidavit
Clarifying.
clarifying that you are the son of the deceased and whatnot.
Lordship, his statement is there. The Gaupura has himself stated, certified that he is the Rajiv Pegu, he is the son of the deceased. He is certified and he is the authority. The village headman is the authority. He is the government village Gaon Pradhan. It's reflected there. Sorkari Gaon Pradhan.
Okay, where are we?
Affidavit back.
So in this respect, she has relied upon a certificate issued by
The village headman.
the village headman of which village?
Of Boroli Mara, Potharisuk, Lat village, Dhemaji district.
Dated
28.
Just say the village headman of which village?
Borali Moria, if your lordship, yes, Borali Moria, Potharisuk, Lat village,
Which district?
Dhemaji district.
That's right. You got it? Then you were living with your mother earlier,
Yes, Lordship, living together.
you're living together with your mother.
Yes.
If you're living together with your mother, madam, your address should be Dhemaji district. What is Lakhimpur?
No, no. Presently, Lordship is in Lakhimpur jail. I'm sorry. Lakhimpur है वो लगे ना?
Your address shows that your affidavit, your application shows that you're in Lakhimpur. But your mother died in Dhemaji
No, no, no.
and you're
Lordship.
living with your mother.
Lordship, this was done very hurriedly. Originally, they are from Majuli, but this is government of Lakhimpur itself, Lordship. Well, I think that's Lakhimpur is the better.
I think you get your house in order.
Lakhimpur, it's
Huh?
Lakhimpur.
If it's Lakhimpur, then why are you getting a certificate from the Dhemaji
No, it's
district?
not reflected Dhemaji district here. Actually, I said it's Dhemaji, it's the.
You get a proper certificate from the, you say you get a proper certificate from the thing, from the.
District is not reflected in the certificate.
And
This is
you
the
said
official.
district, you said Dhemaji.
No, Lordship, I'm sorry, Police Lordship, it's a mistake, Lordship, it's Lakhimpur. In fact, in the certificate, the district is not reflected. Lordship, in this, in that moment, Lordship, they cannot get. No, not, it's Lakhimpur
Now,
itself.
now you see, I'm not able to read this Assamese, but this round circle here, this seal,
So Majuli,
this is Majuli
it's
now.
Majuli, not
Yeah.
Dhemaji.
No, Lordship.
Your left hand is somewhere, your right hand is somewhere else,
Originally
your mother is
from-
somewhere else.
Yes, it's reflected originally they are from Majuli.
Then
That
you have
is
to
very
sign
Then where
not
are you?
reflected.
You sign
He's in
that.
Lakhimpur jail.
And where is she? Lakhimpur.
Lordship, yes.
Please clarify, madam. I don't know. She's the expert in this because I can't read Assamese. I mean, between us two.
No, Actually, tomorrow I'll clarify. We'll clarify.
Yes,
Actually, tomorrow I'll clarify. Let it come up tomorrow. I'll clarify. Yes,
I think you should. Okay,
Yes,
what have I
yes.
said?
tomorrow.
What have I said? What have I said? Full stop. The petitioner's address, applicant's address in the affidavit shows that he's from Lakhimpur district. While the seal, while the round seal made in the certificate issued by the Gaunbura is shows Majuli district. So, on the prayer of the applicant's counsel, list the matter. When?
Tomorrow, Lordship.
Tomorrow. If I don't know which bench is constituted tomorrow. Oh, that matter.
That matter. I have to reply. I think not much time left. And Lordship Nandi has a single bench. I'm told.
Yes.
I can finish it early. I have to show the circumstances. Chief perhaps remembers everything.
No,
Facts.
that is not the issue. No time. Because we'll have to write and go through. Some other day maybe. Even I have got single bench
Lordship also has. Oh,
judgment.
acha.
So my sister got
5-6 matters.
no time. Some other day. Or you can try your luck with some other bench.
They have already done it, so I just.
No, it's
didn't
kept
want-
parted most probably.
No, we have not put it password. We have ensured that we don't make that type of mistake.
That's it. I leave it to you.
Otherwise, it's a democracy sort thing.
Lords. Then next week.
You think of this, huh? Pick it out and give it to me. I'll take it out now.
On simpliciter, conviction, simpliciter on 302, I found out decision saying that it can be done. Provided I can show materials that he was the person who had actually given the blow.
That evidence is not there.
That has to be given. Otherwise, without the charge, simpliciter under 302, conviction can be given. As far as the law is concerned.
Right. On the prayer, the parties list the matter the next week.
Come on.